of the Chief Justice and other matters arising. We do know that now removed Chief Justice here to Tokornor seeking some reliefs at the ECOWAS court. That saga certainly has not ended. Our colleague Joseph Akable sat down with the Deputy Attorney General, Justice Shremsai, and had a conversation with him about these matters. Let's take a listen to that. When we come back in studio, we put some more flesh on the bones. And this is still 3FM Sunrise on 3FM 92.7.
Dawn, we woke up to another process which was served on us from the court, that the former Chief Justice is seeking judgment in default of defense. In other words, that we've not defended the substantive suit. We had 30 days to do so, and that we have not filed our defense. But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the ECOWAS court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment.
The best in the morning is on 92.7 Sunrise on 3FM.
3FM. And we'll do well to bring you that fuller conversation where the Deputy Attorney General and Minister for Justice, Justice Shremsai, sat down with the Media Generals, Kofi Akable. Get into that conversation a bit. Also, he earlier sat down with the former Chief Justice of the Republic, Ladyship Sophia Kufu. And you're always welcome to send us your thoughts and comments as we connect with you and yours around the world at 3FM 927. That's our Facebook handle. You can't miss that. You certainly have to be part of the active society. Article 146 has been followed to the latter according to the government spokespersons and according to the committee chaired by His Lordship Justice Poaman, Gabriel Scott Poaman, that is. Was not alone, was with the likes of former Auditor General Daniel Yao Domelevo, Military Major, and three others who formed the Committee of Five according to Article 146. That had been occasioned by the reception of a petition from the presidency or the presidency from a certain private individual by the name Daniel Ofori, who had also petitioned for the removal of the Chief Justice now, a Ladyship Gertrude Araba Esaba Saki Tokornor. That removal has come with a lot of commentary on the side. Some say, well, it's the day the judiciary died. Some say this is grounded in politics and not law. And some say that, well, The government of the day could have done better because this certainly weakens the institution called the judiciary. For the former Chief Justice, Justice Arabe Saba Saki Tokornor, is impressing upon the ECOWAS court where she had earlier gone to seek some legal favor to rule in her favor because she says that the Republic of Ghana failed to enter a plea, or so it sounds. Well, the Deputy Attorney General and Minister for Justice, Dr. Sremsai, has been explaining his position and the position of the government, that is, to Mr. Akable, my colleague here at Media Journal, soon to be called to the bar. That's a semi-esquire Akable. 6-2s don't always also semi-esquire. Very, very soon when the call comes. They are charging their phones, so call will come very, very soon. I can tell you that for a good reason.
No one touch out.
But as commentary flows in, some say, well, the removal of the Chief Justice based on the committee's report, the Justice Puaman Committee report, is the way to go. Some say it is not the way to go. The minority leader, Kwamina Apenyomaking, or Sahin Alexander Kwamina Apenyomaking, MP for Futu, says, well, at the appropriate time, they will talk about it. It was in Akwetia. He made those comments on the sidelines of the by-elections that happened at Akwetia. Parliament shall resume very, very soon. I'm sure that when Parliament resumes, it will be one of the conversations that will take center stage. The former Chief Justice, we know, is still at the ECOWAS court, and we do not know yet if when the ECOWAS court takes a decision, it will override what has been done here locally. Per a warrant that was signed by the President of the Republic, John Dramani Mahama, on the 1st of September 2025. But what reliefs are being sought by the former Chief Justice in ECOWAS court, Helen?
All right, let's take a look at that. Now, the relief sought by former Chief Justice, an order of the Honorable Court entering a default judgment in this suit in her favor due to failure of the defendant stroke respondent, that would be the Republic of Ghana, to file a defense. And for such order or any orders as this court or the ECOWAS court may deem fit.
Interesting. So this the former CJ is bent on it, but the explanation that was given by the Deputy Attorney General, if that's anything to go by, he gave a very interesting explanation to suggest that both the original matter and the injunction that was placed on the issue were lumped together by the ECOWAS court and adjourned for conclusion of the matter at a later date. So they do not see how the learned former Chief Justice wants to decouple the two and single out one, and say that the court should base their decision on one. And he's been explaining. We'll get that tape for you in a bit. But just so you know that currently we have an acting Chief Justice, Justice Paul Bafuboni. The President will have to do some consultations in order to either endorse him to be Chief Justice or to find a replacement for him, because thus far he's been acting as Chief Justice of the Republic of Ghana. And some say that, well, the Mustafa Gbandi, for example, is Deputy General Secretary of the NDC, is also a security operative operating from the Office of the President, indicated that the former Chief Justice's support of her leadership, Saki Tokornor, is just a feminine agenda of one woman supporting the other, and not necessarily something that is grounded in law. And you could clearly tell the disappointment of the former Chief Justice, in the decision that was reached by the committee. It's interesting days in Ghana, is it not?
Absolutely, and I've also monitored those comments. I know she was also disappointed that information was leaked, that she stood in as a witness on behalf of the now removed Chief Justice Gertrude Tokornor. So she's been speaking about her feelings on the issues.
There's also the conversation about whether or not she's breached the oath that members of the Council of State are supposed to take, and whether or not she coming public to suggest that she departs from the decision that was taken collectively by the Council of State to when the president consulted them whether or not they should go ahead and find a prima facie case, whether or not she was in full support. Some say that that's a breach of the oath she took as a member of the Council of State. Know that the Council of State has a unique composition. And her place as a former Chief Justice of the Republic, she has a place in there. Former IGP has a place in there. Former Chief of Defense Staff has a place in there. And then you can go on to the other appointees and those who are elected but on regional basis to be part of the Council of State. So the conversations are ongoing. But listen to excerpts of the interview with the Chief Justice Emerita, her leadership, Sophia Kufu. Joseph Akable sat down with her. Listen.
I'm very sad about it. It has really saddened me. And maybe in a way, I feel very distressed by it. Yes.
In terms of
about it, it has really saddened me. And maybe in a way, I feel very distressed by it. Yes.
In terms of the conclusion that was reached, is the sadness as a result of the conclusion, or you have questions about the procedure that took place before that?
The sadness is about the whole process. My sadness is because as far as I'm concerned, it was a very unnecessary. We have been taken through a very unnecessary situation, and which, as far as I'm concerned, and that is my honest and candid view, this has so weakened the institution of the judiciary. It's not so much the individual who occupies their position. It is the institution. That is what I'm concerned about.
I mean, what informs the conclusion that it's an unnecessary process? I mean, we have heard even government spokesperson make the point that a petition was sent, a committee in line with the Constitution was set up, they've looked into the matter and they've come to a conclusion. Which aspect of it, what specifically makes that necessary?
I think that, you see, there has always been something wrong with Article 146, and particularly with the procedure that it sets out, and especially as it regards the position of the Chief Justice. In the Ajay case, I took the opportunity to reflect on that weakness that I noticed, and these are not so, to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every Chief Justice is also fair game.
I mean, is that to suggest that you suspect there could be a ripple effect in that?
Oh, definitely.
Any matter?
It's not suspect. I foresee, not tomorrow, maybe not next year, maybe not in 5 years' time, but along the line, yes, unless those provisions are dealt with effectively in a revised constitution.
Maybe a more direct question. I have seen the letter that was written by the Secretary to the President to the former Chief Justice.
And that's the other thing. A warrant, a person holding a presidential warrant.
On 3FM, the best in the morning.
That's what the position is. You become Chief Justice because you have received a presidential warrant. You can receive all kinds of letters that you are hereby appointed, but if you don't have that warrant, does that make you Chief Justice? Yeah, okay. So if you're removing the person from the position, is it a subordinate who signs the letter? Is that the way it's supposed to be done? That's just by the way, food for thought.
Yeah, but I've seen a warrant as well signed by His Excellency the President.
So why are they showing us that one? I've been receiving all kinds of messages, and every one of them is only bringing out that letter. And in any case, is it polite? Is it proper that it should be a subordinate who writes a letter of removal to a Chief Justice? Really? Really?
The best in the morning is on 92.7 Sunrise on 3FM.
Now, I'm looking at Helen there, the oath of the member of the Council of State. And it reads, I, and then you fill in your name, do solemnly swear in the name of the Almighty God, solemnly affirm that I will faithfully and conscientiously perform my duties as a member of the Council of State and uphold, preserve, and protect and defend the Constitution of the Republic of Ghana. So help me God. That I will faithfully and conscientiously perform my duties as a member of the Council of State and uphold, preserve, and protect and defend the Constitution of the Republic of Ghana. So help me God. In upholding, preserving, protecting, and defending the Constitution of Ghana, the Constitution of Ghana per Article 146 says that all the processes regarding the removal of the Chief Justice or a Justice of the Supreme Court or any other person who is captured within that domain or that province should be held in camera. So people are asking questions that if her ladyship, the former Chief Justice Sophia Kufu, now has come out to tell us what she did and what she did not do within the confines of the Council of State, which is supposed to preserve, uphold, protect, and defend the Constitution of the Republic of Ghana, then certainly there's a problem somewhere. Is she breaching the law? Is she engaging in stated misbehavior? People are asking those questions, and must she not know better? These are questions that are being asked on the street. I am no lawyer, so I cannot explain what that means. But that's one leg of the conversation. Again, on the streets, the conversation is that, okay, if you look at the posture of the former Chief Justice, and she had gone in support as a witness to, or witness for, her leadership, bring your name, Saki Tokornor, right? Along with Justice Eni Eboa and Justice Jones Doche. These are three towers in our judicial system. All of them retired anyway. But if you listen carefully to the tone, it does suggest that, oh, but this is nothing. This is okay. But really, what's so? Because the last word is said, really?
Really?
Like, what is it? $10,000 to pay for this? Really? Does that give us an indication that in the past these things might have been done and then the country glossed over it? It's a conversation that, you know, we ought to pay attention to. I saw something from Professor Kwekwaza, who wrote a petition in the erstwhile administration to have the former Chief Justice, now former Chief Justice, kicked out of the of office. That petition was not followed through. For the President of the Republic at the time shelved it and thought that there was no merit. But this is what he wrote nine hours ago, Professor Asari. He says stated misbehavior under Article 146 is not a boogeyman. Stated misbehavior is not a novel constitutional creation. It is rooted in the common law and has long been used in Commonwealth jurisdictions to justify the removal of public officers whose conduct undermines the integrity of the office. The Supreme Court in the J. Chum versus Attorney General 2005 to 2006, Supreme Court Ghana Law Report 732, interpreted stated misbehavior broadly to include corruption, abuse of office, bias, or other conduct that undermines public confidence in the judiciary. Importantly, the court rejected the idea that the administrative acts of the Chief Justice fall outside Article 146, as the court explained. The plaintiff's argument on this issue is founded on the fallacy that a Chief Justice's conduct in the administration of the judiciary can never ever be construed as a stated misbehavior or incompetence within the meaning of Article 146 of the Constitution. As far as the Chief Justice is concerned, I think it is reasonable to link his conduct of his administrative responsibilities with his position as a justice of all the superior courts. Justices of the superior courts are required to adhere by certain judicial ethics, which can be infringed by the conduct of a Chief Justice in the performance of administrative acts. It is therefore unacceptable to exclude a priori all administrative acts of the Chief Justice from scrutiny as possible evidence of stated misbehavior in his capacity as a justice of the superior courts. This passage affirms that administrative conduct is not immune, where the Chief Justice abuses, transfers powers, manipulates case assignments, or misuses administrative discretion. Such actions may properly constitute stated misbehavior under Article 146. It is therefore clear that stated misbehavior is more than casual misconduct. It requires one, specificity. The acts must be clearly alleged and capable of proof. 2, seriousness. Trivial mistakes, errors of judgment, or mere disagreements do not suffice. 3, connection to judicial office. The conduct must relate to judicial functions, the exercise of judicial power, or the administration of justice. Applying this definition and the guidance in Ejechum, the following allegations, if proven, fall squarely within the constitutional meaning of stated misbehavior. 1, financial impropriety. This implicates integrity and honesty, both central to judicial office. Misuse of or mismanagement of funds erodes public confidence and constitutes classic misbehavior. 2, interference and tampering with judicial proceedings. This goes to the heart of judicial independence. Any manipulation of proceedings violates due process and undermines the rule of law. 3, abuse and misuse of transfer, dismissal, and case assignment powers. This illustrates arbitrariness and administrative abuse. If exercised for improper motives, such powers become tools of intimidation and bias, contrary to Articles 125, 127 on judicial independence. 4, contemptuous disregard for judicial process and the judicial power of the courts. This constitutes insubordination to the very judicial authority the officer is sworn to uphold. It undermines the legitimacy of the judicial system. 5, capricious and arbitrary fixing of cases for hearing. Case management powers must be exercised fairly. Arbitrary scheduling prejudices litigants and weakens faith in judicial impartiality. 6, undermining the independence of the judiciary. This is probably as serious as it gets. Judicial independence is a constitutional value under Article 125 to 127. Any conduct eroding it, such as circumventing established processes for nominations and directly lobbying the president, amounts ipso facto to misbehavior under Article 146. We must not lower the bar so far that misconduct is excused under the guise of discretion, regardless of who is accused, and no matter the spin, ask yourself these questions. If the answer to any of this is yes, then the conduct, if proven, amounts to misbehavior under Article 146. 1. Integrity. Did the act involve dishonesty, corruption, or financial impropriety? 2. Judicial function. Did it interfere with the fair administration of justice or tamper with proceedings? 3. Abuse of power. Was authority exercised capriciously, arbitrarily, or for improper motives? 4. Respect for process. Did the conduct show contempt for established judicial processes or procedures or the authority of the courts? 5. Judicial independence. Did the act comprise the autonomy of judges or independence of the judiciary as an institution? Judges, by the power vested in them, can do more harm to the polity than any other public officer. As a result, they must be held to a higher standard, never a lower one, as is being advocated by some. The J-Chum Court case also addressed the concern of executive interference in the removal process. It clarified that the president's role in initiating Article 146 proceedings by constituting a committee does not in itself undermine judicial independence. Moreover, the fact that it is the president who establishes a committee under Article 146 to investigate an allegation that a chief justice has been guilty of such misfeasance of his administration or administrative responsibilities as to bring him within the meaning of stated misbehavior under Article 146(1) does not necessarily imply executive interference in the affairs of the judiciary. Thus, the president's role is procedural, not substantive, and the safeguard lies in the independence of the committee process itself. The attempt to spin Article 146 proceedings as executive interference must therefore be firmly rejected. Please, the post no better ho. Yenye comprehension consultants the year. Helen, you are the comprehension consultant here. What did you glean from this?
This one day I have to sit down, also reread it, and then make some notes out of this. But I mean, the crux of the matter is that a lot of the, I think, critique seems to be misdirected. We keep hearing the executive, the president, President Mahama, seemingly as though he has made this decision. But I don't know how many times it has to be reiterated what the processes are, and ultimately that this came from the recommendation of the committee. But those that are hell-bent in misdirecting and misrepresenting the conversation,
their mind is made up.
Their mind is made up. Their mind is made up.
You know, what this says to us is that, look, judges have a place of pride within our polity, and you must hold them to the strictest and the highest standards. If not, they would use the powers of discretion and push people into places that they are not supposed to go to. So they have to be held to a certain standard.
Yeah.
And I couldn't agree less with
far higher than you and
everybody
I,
else, yes.
100 times higher.
If a judge can commit you to contempt or commit you for contempt, you know, per matter of discretion, it may be that the judge perhaps that may not like you and will say, Chale, go and spend 2 weeks inside and so on. If it's stated misbehavior, it comes out that you have not done anything that should warrant that kind of punishment. It's stated misbehavior, and the judge must be dealt with in a way that Article 146 prescribes. You know, I really mean. But your thoughts and comments are always welcome here on Sunrise on 3FM 92.7. Come on. I know you have your own comments. Make sure you're on the side of the law. Don't go and be saying things that you don't have to say that will put you in trouble. Anyway, Sati, Bonu, that's a goma. Chief Justice is just 62 years old, and that the next NPP administration can reinstate her to her position. Gloria Oforiboidu, she was on New Day a while ago. She said Justice Tokornor is just 62 years old and she can be reinstated. Yeah.
Okay.
Reinstatement Mugalo.
3FM Sunrise. The best in the morning is on 92.
Rest on lack of clear laws in place and everything. To the extent that the committee was exercising discretion and their own understanding of some of these laws and applied it, would you disagree or agree with those who say that no clear-cut provision has been breached in terms of from the start of the procedure for the removal to their conclusion?
Well, what procedure? That skeletal framework that's in the Constitution. See, that's a very. I want to take you back to the Ajay case. See, in the Ajay case, the court. Matters had only just begun. The process had only just begun. So we couldn't really go deeply.
Sunrise on 3FM, the best in the morning.
Yeah, but if I'm to ask directly, would you say that the former Chief Justice got a fair trial, if I'm to put it in that manner?
In my you want my opinion, you want my legal opinion, you want an opinion from the heart and the mind and the soul and the spirit. No, she didn't. She didn't. And there were also other things which in the latter part of the proceedings also happened, which you know, I don't even know how to put it, but they were very unbecoming. One, a process that is supposed to be purely in camera, and that expression in camera has been defined by the Supreme Court, and that definition still remains, right? That from the complaint all the way till the president speaks at the end of the matter. It's all what? It's all to be treated as part of the same thing. It comes under the same cover of in camera, and therefore is supposed to be confidential. So you can imagine the umbrage that I felt to receive on social media some social media thing somebody had sent to me, where the fact of which I am not in the least bit ashamed, and if I had to do the same again, I will. The fact that I had gone to give evidence before the committee was on social media. How did that get there?
Sunrise on 3FM,
it was not
the best in the morning.
So and 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 so. I'm not going to repeat that. I won't use the word that came on my lips. I'm not going to repeat that unbecomingness by even mentioning the names that were mentioned. Isn't somebody entitled to have every witnesses on their behalf? And then to come to think of it, then I thought, yeah, but we don't even know who gave evidence on behalf of the petitioner. So why is it that those who gave evidence for on behalf of the respondents, why should we be thrown to the rabid dogs? Because there has to be some not very noble motivation for that. And when it says that they from quote and unquote sources close to the committee, oh really, that is so sad and it's so pathetic. And then on Sunday somebody sends me another thing where somebody's going on and on and on and on and going on about the legal submissions that had been filed on behalf of the petitioner. Really? Why? What's the game? What's going on? I felt sad. And even that in itself made me sad. Have we come to this in this country where a process, the most important thing in every process, whether it is a formal judicial process,
Sunrise on 3FM,
the
the
most
best
informal
in the morning
process, such as, let's say, ADR discussions and all that, where something is supposed to be confidential, it has to be kept.
But to the extent that the Supreme Court has determined that if there is a breach of the in-camera rule, it does not invalidate the process, should that still be of concern?
That's not matter. I'm still talking about it. Just because it doesn't breach it, it breaches the letter. It breaches the letter of the Constitution. Does it not? That it should be confidential. I'm not saying it therefore means anything, but all I'm saying is that for me, it puts an unpleasant aroma onto the procedure, because process integrity is exactly that which is demanded of the most humdrum, the most mundane inquiry.
That was Her Ladyship Emerita Sophia Kufu there, sitting there with Akablay. Now, let's go on and listen to the Deputy Attorney General and Minister for Justice, Dr. Edem Sremsai. He sat down with Akablay again on the same issue, because you do know by now that they removed Chief Justice Saki Tokornor, JSC, has insisted that she wants the ECOWAS court to rule in her favor. Let's now listen to Edem Sremsai with Joseph Akablay.
Come to this special conversation with the Office of Attorney General. Our guest today is Dr. Justice Sremsai, Deputy Attorney General. And Doc, thank you so much for agreeing to speak to us.
Yeah, thank you so much for giving me the opportunity.
It's been a busy last couple of months, particularly with the issues surrounding the Chief Justice, the former Chief Justice, and the process eventually terminating, the President writing to communicate that to the former Chief Justice. From the perspective of the Office of the Attorney General, what's your own assessment of that entire process that has taken place?
Thank you very much. I think this situation has given us a very important lesson in our strive to run a democracy. Issues have been raised on the independence of the judiciary. On the other hand, issues have been raised on rule of law. Opinions have been offered on whether the process is correct and whether it should be changed. One thing which, however, stands out is the understanding that everything that we do under the Constitution must conform with the provisions of the Constitution. And this process in particular has been tested, whether or not it's conformed with the provisions of the Constitution. It's been tested in at least 5 cases in the Supreme Court, 2 in the High Court, and the conclusions have been the same. In fact, every aspect of the process has been tested in the courts, and the conclusion has been the same, that it comply with the processes with the processes prescribed in the Constitution. And for me, that indeed is what rule of law is about. The fact that actions, whether by the president, whether by the Council of State, or whether by the 2 of them combined, could be tested in court to see whether they are indeed in compliance with the Constitution. I think the process has survived that. I refuse to mention that it's been tested in the ECOWAS court as well. From where I sit, I believe the outcome would not be different from what the courts of Ghana have given. So I would say that indeed it was tested, it has passed the test, not from my perspective, but the perspective of the courts.
But from the perspective of the AG's office, do you find that the process that the former Chief Justice went through was a fair process, such that she had an opportunity to put across her case fairly, and the conclusions reflect what should be the conclusions? So
let me begin by saying that this office would never condone any unfair treatment of any public official or any Ghanaian. That is the fundamental, that we occupants of this office will not sit down and oversee or condone or partake in a process which we know is unfair. From that, I believe what I have to say is that by the standards of this, by the Constitution, and this office is completely and absolutely of the view that the process complied with the law and has been fair, it has been reasonable, it has been legal.
I mean, the president's role, 2 key roles. The first had to do with receiving the petition itself. Then eventually he did a prima facie determination in consultation with the Council of State. That particular determination has come under some scrutiny. We've heard from a former Chief Justice who has said strongly that from the letter that has been written to the former Chief Justice, Justice Tokornor, she does not find the conclusions, the 3 issues that were relied upon to form the base of the removal. She does not think that it even crosses that minimum threshold, bringing into question the determination that was done by the President with the Council of State.
Well, it's a very difficult one to take from a very respected former Chief Justice of this Republic. She's demonstrated her competence for so many years. She served her term without blemish. She's been recently, even going beyond the law to, contribute to public discourse on various aspects of the country, sectors of the country, economy, and all that. We may all have our opinions on how things are supposed to be done, but we also know that due process is the answer to some of these contentions. I think the issues are 2. We are looking at, we need to make a choice as a country, as a people, okay, as to the standard which we hold public officials. We need to make a choice. My understanding of the Honorable Retired Chief Justice's argument is that not that a wrong has not been committed, but that a wrong was committed, but it is a kind of wrong which should be allowed because of the person or the office involved. I think that is my understanding. I don't know. You interviewed.
Yes, I mean,
do I represent her fairly?
I mean, to an extent, I mean, largely. I mean, I wouldn't disagree at all. But I mean, if you pick one of the grounds, for instance, so the bit about the travel expenses, her response is that, well, if the auditors had any concerns, the auditors should flag it. If there is to be a refund, there has to be a refund. So she doesn't understand how that, for instance, should amount to stated misbehavior.
Well, in this country, okay, I think it was when Parliament approved the spouses of presidents to be given some monies or emoluments. The issue went to the Supreme Court, whether it was valid, right? I think the Supreme Court decided that there is a process through which you should go to include persons, and that so long as that process has not been followed, you cannot say that it is lawful to make such payments to the spouses of presidents and the vice president. This is even after Parliament had made a recommendation. You know, it was tested in the Supreme Court, and that was the outcome. So, why should it be that the president can at will give money to people? Even Parliament cannot at will give money to people, spouses or family members of the president, and then in another case, we would say that it is, we should. And the question of, I said it's a question of standards, Maybe it is, we have to make a choice as a country whether we want our leaders to be excused from some of these things so that they can do it, and then we just ask them to return the money. Recently, where I sit, I prosecute people, okay? So many people in this country, when they commit a certain crime, we jail them 5 years, 10 years, and all. So if the position is that we should excuse leaders or those who are at the top of the, let me call it the political food chain, to do certain things without holding them to account, we can adopt that as a country. And if the other school of thought is that for persons who are at that level, they should even be held to a higher standard, in the sense that they know, they know and ought to know that this should not be done, right? So if they allow that to be done, we have to decide that we will leave them to go or not. But I believe that the standards have been considered by a panel of 2 Supreme Court judges and 3 other persons, with the former, auditor, general. I would defer to their, conclusion as against their appreciation of the standard as against the former Chief Justice.
But do you not see the point she makes, perhaps, that to the extent that she doesn't control the purse, I mean, she's traveling, they make arrangements, they give her what they ought to give, and eventually now it turns out that, well, what she has received is in breach. Should that not cure it? Should that be a basis for a removal of a Chief Justice from office? Do you think that that is not a bar too low? What do you make of that?
She was given, and she received it, and she didn't do anything about it. So she should be allowed to keep it. It doesn't sit right with my thinking.
Okay.
It doesn't.
But how about the role of the auditors? I mean, at those levels, because that's why auditors, exist in various agencies.
Auditors have given their reports. Is that not the case? The reports were given how many years before this hearing? So if there was any attempt to remedy the situation, it would have been done. And I don't think there was any attempt. I think the issue was whether the now outgone Chief Justice is entitled to it or not under law. The committee says she was not entitled to it. I don't think it's a question of remedy as the former Chief Justice is putting across. It's a question of whether a wrong was done. And I don't think that the argument before the committee was one of whether it should be remedied or not. The committee, what I understand the committee to have said from their conclusion is that it is something that ought not happen, and it happened. And so the conclusion was that if it's stated misbehavior. The stated misbehavior simply means that something which you shouldn't have done, considering where you are. So it shouldn't have happened. Whether the former Chief Justice received it or whether she gave it, it shouldn't have been done.
I mean, the other issue had to do with the appointment of Superior Court, specifically Supreme Court judges. And again, the former Chief Justice takes the same position that she had written. And particularly, she makes the point that to the extent that there doesn't appear to be a clear-cut procedure in the Constitution, even though the various age arms that are supposed to participate are mentioned. We do not know how it commences. From whose office should the names come up from? Should they start from the Judicial Council? Should they start from the Office of Attorney General? And that in that regard, if she has written a letter giving such names, she doesn't think that sidesteps that process. Is that something you are...
There is a fundamental rule of, principle of law. For a public officer, you have no power to do something unless the law authorizes you to do it. So if you do something which the law doesn't authorize you to do, there's a process called a writ of quo warranto. If you are going to court, they'll ask you, who gave you the authority to do that? By which mandate did you do that? So this is not the first time we are proposing persons to be appointed to the Supreme Court. The constitutional law has the letter of the law, it has its spirit, it has conventions and practices as well. So the impression should not be created as though nobody ever knows how to appoint Supreme Court judges. It should not be said that we don't know how the list, is generated. The question is, do you have the power to generate lists? If you have it, you've not done anything wrong. But if you don't have it, then there must be some stopgap. I mean, we cannot allow. Right now, there are things that I can do, and there are things that I can't do. If I don't have any authority to do something and I do it, I think I should be ready to accept the fact that
3FM,
I have breached the law
92.7
and not create the impression that nobody knows how to do the thing, so I'm doing it the way I think it should be done. There have been so many countless under the 1992 constitutional law. There have been so many appointments. Currently, we have we've had 18 persons on the bench. All of them were appointed, and they all went through a process. So it cannot be that we do not know how a person is appointed to the Supreme Court.
But to the extent that the recommendation went, the appointment was not even done, do you still think that, as far as you're concerned, that meets the standard as well in terms of crossing the threshold?
So the appointment didn't go through. Why? Because some people stood up to authority. I think that is what we should be concerned. So people risked their liberties, their everything to stop it. So, and you know what it takes to oppose people in authority in this country. So if it was stopped, we shouldn't say, I don't think that it's a very strong argument to say that it was stopped by some people, so we should let it go, or we shouldn't think about it.
I mean, what does the office feel generally about the former Chief Justice, Sophia Akufu's comments on this process, given the position that she occupies, the body that she belongs to basically took part in the process, and she's publicly raising such matters about the entire process that has taken place?
No, I have this is my personal opinion on the matter. I have a very liberal outlook to some of these things, okay? I think there is an issue on board. The former Chief Justice feels strongly to comment, which I believe she has the right to do. It's for the public to assess the quality of the comment, the weight to put on it, and within the context of what you have said, that having been part of the process and having testified,
and she was a member of the Council of State.
She came and testified in the committee. So I think I would take the Honorable former Chief Justice's comments as re-echoing. She has already taken side by going to testify, even though I don't know whether it was expert's opinion or expert witness, or just to testify to the facts. But the point is that she has taken part in the proceedings, has testified in the proceedings. So coming out to repeat the same thing, I would take it within that context. That and I think the Honorable former Chief Justice also said that she's not ashamed to support. I think that's the. In
fact, she said if she had the opportunity, she would do it again.
Yes, so she's supporting the former Chief Justice. That is her position. So I think she's entitled to continue that support.
I mean, early on, you made a point about concerns that have been raised over the period about judicial independence. There are those who look back at those comments and they make a connection that there was a clear discontent that even the current president, he publicly, made that comment many times about the need for judicial reforms, that it is that commentary prior that has been engineered in a manner that fits within the current legal framework to reach a certain conclusion.
No, that is misplaced. It is completely out of place to suggest that because there was a policy, a campaign proposal or policy that the judiciary will be reset, then it means that anything that happens within the framework of the law is to malign or take away the independence of the judiciary. That doesn't connect as far as, and I believe you should agree that it doesn't connect, because does that mean that because the president made that promise, so if there is any wrongdoing and the petition has been brought, the president shouldn't act on it because it will be said that, it will be a very difficult argument to carry through. So for me, the reset agenda has to do with institutional, structural, changes in not just the judiciary, but all arms of government. And you can see there's a constitution review process as part of the reset. We have 24-hour economy, which is part of the reset. We are looking at so many other aspects in terms of education, how school fees are paid. That is part of the reset. So you cannot reduce the reset agenda to a petition brought by how many people going through the process as an indication of that. Look, the judiciary needs a lot of structural, logistical, changes. We are still here doing paper filing. Cases drag on for years. The average time for a criminal case to terminate, even a summary trial, is 2 years. 2 years. So if you arrest someone, unless the person pleads guilty, if you want to take the person through the criminal procedure, the shortest time limit for you to get conviction is about 2 years. That is not right. We sit in this country, we saw things happen in other jurisdictions. Someone is arrested, and within a few months, they've finished the trial. The person, if jailed, has been jailed. Some people even finish serving their term before a simple case. So those are some of the issues that the reset agenda is talking about. We are talking about electronic, assistance with the court system. Those are the issues, and to strengthen the independence of the judiciary. Now, let me flip even to another point. Now, let's look at this. Is it the case that whenever a chief justice is removed, then is an attack on the judiciary? Or when there is accountability, persons in judicial office are held to account, then it's an attack on the judiciary? Or is it that the office of the chief justice is above the standards, or is above the law? What exactly is the point? Because this is also not the first time that we are seeing a justice of the Supreme Court. Well, this is the first time a chief justice has been removed, this way, in accordance with the Constitution. But other justices and other persons who are ranked in the same, at the same level, have also gone through this same process and have been removed. And I think the time they were being removed, there was no question as to whether it was a question of whether it's an attack on the independence of the judiciary.
Do you share the fear that some have expressed about the ripple effect, the likelihood that more petitions will be coming through, not necessarily in the immediate future, but potentially when there's a change in government?
No, I don't have any fear. You see, there's no fear about that. If an occupant of an office, as the office of the Chief Justice, is removed based on merit and is subject to the process of the law, why should we look? It is really, for me, it is better, to have chief justices change frequently for a better judicial system than to have chief justices stay for a very long time when we have issues with justice. So I personally don't have any problem with justices changing, so long as there's merit in it. If you appoint a chief justice today, and tomorrow, even under the same government, tomorrow there's the chief justice does something which warrants removal, and is removed,
92.7.
With all due respect, I think that should be accepted. It also has another dimension, then it means that persons who occupy that office would be able to, keep themselves above certain, standard. But a situation where it's as if we don't want to hold Chief Justice to account, or that we want to lower the bar for, persons who occupy certain offices because of where they sit, I think that is more dangerous than anything.
But if the change should be taking place based on which party should be in power, that will not be good for the country.
Those who make that argument, is it the case that they want the Chief Justice to, it's a process, okay? So long as you're able to prove that, one, incompetence has been, if you're able to demonstrate that the person in office has been incompetent, if you're able to prove that the person has misconducted him or herself, or that the person is infirmity of mind and body, that is the principle in the Constitution. 3 grounds. If you're able to satisfy any of the grounds, the person goes. And I wouldn't be looking at the fact that the person is coming with the president and is going with the president. And would you want a Chief Justice who has misconducted him or herself, or who is incompetent, to remain in office across presidents, or you want Chief Justices to be effective in their offices across presidents? I think that is where the question is. Do we want a certain standard to be kept, or we want just the person to be in the office for as long as we want? Don't you think that there's another side of this which would keep the occupants of the office on their toes? Because, for example, when I listen to the former Chief Justice, I get the impression that she herself probably has been doing some of these things when she was, or did some of these things when she was in the office, because clearly she didn't think it was a big deal, right? Let me ask you, is it a big deal to you? No, I want you to, is it a big deal to you? This, the allegation we've heard, which is not being denied by saying that it is just something small. Is it a big deal to you? If it is it? I want to know first.
To the extent that a committee has looked into it, I think what we have as a fact-finding matter is what a committee has put out there. But I'm asking you, in your assessment, a direct question, which I asked.
Let's among this first. No, let's among this first.
Yeah.
You see, the former Chief Justice is not saying that the allegation is false. Her position is that
it doesn't meet the standard.
It is normal. Let's let it go. Let it slide. Which gives me the impression that perhaps even when she was in office, probably she was doing the same thing. And I'm asking you.
That would just be an assumption that you.
That is clearly an assumption. That's why I said it's an impression. Now I'm asking you, is it cool? Is it cool for you for such things to be happening?
I would want you to answer that. I would want you to, because the point I'm making is that a committee has looked into the matter, but from where you sit, I don't know to the extent to which you've seen all the processes, which we may not have been able to see. A direct question to you: do you think former Chief Justice Gertrude Tokornor misconducted herself?
The committee's findings show that she did, and I have no basis to question the committee's conclusion.
From your independent analysis, you agree with that conclusion?
The truth is, I don't have the facts and evidence that was put before the committee. I didn't witness anyone being cross-examined. I couldn't have formed an opinion different from that of the committee. But
the allegation that has been put out, to the extent that we know it, at least the letter that was written, it summarizes those 3 pointers which we've discussed. You hold a view that those allegations can form a basis for that conclusion, if they are proved at trial.
Yeah, I think the question is, if they are proved, why not?
Okay. And another question on that.
And here they've been proved by the committee's finding is established.
Another question on the issue that I asked about fairness. Do you think the former Chief Justice got a fair trial, if I'm to put it that way?
It is fair, because personally I was involved in. I conducted all the cases in defense of the Attorney General. In defense of the committee, I was the one in court, and my argument has been one that is fair. It is legal. It is fair. It is reasonable. It meets all the constitutional standards for administrative, inquiry.
In terms of the conclusions that the courts reached in some of those decisions, I remember one that you had the judicial review application at the High Court. You had raised the issue that the matters that are in contention have been dealt with at the Supreme Court or remain pending in the courts in one way or the other. There are some who have questioned that decision, for instance. Then they make the point that the grounds for judicial review are different from, for instance, if you go to the Supreme Court to seek to interpret or enforce the Constitution. So judicial review will deal more with the procedure, whether there's been a procedural breach, rules of natural justice, all those matters. And they say that the court could not have relied on those pendency of those matters to conclude in those ways.
No, then those who say that probably were not very familiar with what happened in the High Court. The High Court, the question was substantially whether the court, whether the issue, the High Court has jurisdiction to determine a matter in respect of which the Supreme Court has either seized, or has already made a decision. And the merit of the case was about the process that is ongoing, which has been brought before the Supreme Court. So if you say that the High Court judicial review process is to look at the process, the Supreme Court is already looking at that. And it was sent there not by, the Chief Justice was one of the persons who sent the matter to the Supreme Court to review the process. So the process having been subjected to the Supreme Court's, scrutiny, it is improper and abuse of the court process to bring the same issue to a High Court, knowing very well
that those grounds are not the same, because the grounds, if a matter is taken for interpretation and enforcement, and you make a judicial review application, the grounds which you'll be urging on the court will not be the same, correct?
Well, I don't think the matters that went to the... I am arguing the case, and I'm telling you that it's the same issues. Going to the Supreme Court, the question, most of the reliefs were whether, for example, you need to give a reasoned prima facie, conclusion. It's about the process. The question is whether the committee members have sworn or were administered to the oath of office. It's a process question. One of the questions was whether the Chief Justice, could be about the document being served on the Chief Justice, whether she had been given some... Those are all about the process. So I don't see any... The main cases before the Supreme Court are not about interpretation at all. About prima facie, about in-camera hearing. Those principles have been interpreted in several cases even before this time, and the Supreme Court has a standing position on them, and in such a case, Supreme Court will not reinterpret something that they have already interpreted. So they were all about the process, the fairness of the process.
Okay, let's talk on two main issues, and we'll wrap up on this subject. The first one is the ECOWAS matter that is pending. Where are we on that aspect? Yeah,
so when the Chief Justice, former Chief Justice, approached the ECOWAS courts, raising the same issues that were raised in Ghana, which the courts have been, seized of and have ruled on at the court, at the ECOWAS Community Court. And she applied for interim measures, let me call it interim injunction, so that listeners would understand that the Ghana government, the government should be ordered to withdraw the suspension that was slapped on the former Chief Justice, and also that when the matter is determined, she should be awarded $10 million damages, $10 million as in damages. Those were the issues, but we objected to the jurisdiction of the ECOWAS court, saying that the court doesn't have the power to assume jurisdiction over a matter which the local court, that is the Supreme Court of Ghana, is seized or is hearing, and the courts, ECOWAS Community Court, doesn't have any power to interpret Ghana's constitution for us. Those were the objections we raised on the jurisdiction of the court. This morning, we woke up to a new process. So the court is here to rule on the objections. Yeah, the objections that the court adjourned since that was in June to give a decision on the matter. There's no decision yet. This dawn, we woke up to another process which was served on us from the court, that the former Chief Justice is seeking judgment in default of of defense. In other words, that we've not defended the substantive suit. We had 30 days to do so, and that we have not filed our defense. But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were ahead. It's not as if we argued that matter in court, in the ECOWAS court, and we were ahead. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment, because, like I've explained, the court did not order us to file our defenses.
You're a legal scholar yourself. I mean, the outcomes of that court decision, we know how our jurisprudence operates. Does not, even if we sign treaties, it do not automatically become law here. I mean, the outcome of the decision, whatever decision will come from the courts eventually, how do you see it playing out here in Ghana?
Yeah, so currently, because the ECOWAS court has not been incorporated into our legal system, the decisions of the courts are sent in to us here in the Attorney General's Department, and it's an executive. Within the framework of government, we have the executive, the legislature, and the judiciary. The fundamental principle is that in dualist countries like Ghana, the courts do not see international agreement unless they have been, ratified by Parliament into domestic law. Then the courts can see it. So the Supreme Court, technically speaking, cannot see whatever, or is unable. All the courts in Ghana are, let me put it literally, they are unable to see what is happening in ECOWAS, because we have not domesticated the ECOWAS. However, governments can decide. That is, when I say government, I mean the executive. When it is served on us, the government of Ghana as the executive may decide what to do with the decision. And that is not to say that they have predicted what government of Ghana would do. Government of Ghana would decide whether to grant the award, or, if the court grant the award, whether to pay or not to pay. Whichever way, the ECOWAS courts can hold the government of Ghana to not comply with the decision, because we have signed an agreement. So at the international level, the ECOWAS court is also not aware of the divisions we have in Ghana's executive, legislature, judiciary. They are aware of government, Ghana as a country. So if they give a decision in that court, as far as they are concerned, the decision must be implemented. If we do not implement it, it could be enforced at the ECOWAS court. But the courts of Ghana are not aware of these things. I'm saying it in a very vivid form. They are not aware, or they don't have what it takes to see what's happening in ECOWAS, because Parliament has not yet opened their eyes to what's happening in ECOWAS. So it's a dualist situation. We have domestic law, we have international law. A lot can happen there without coming into domestic law.
A more direct, simple question for an ordinary man. In the event the court, one of the preliminary measures she was asking for was that she should be reinstated when the suspension was enforced. If the court says she should be reinstated, what will happen?
We'll cross the bridge when we get there.
And finally, on this CJ matter, do you think the entire Article 146 procedure needs an overhaul? Particularly, the problem sometimes is the judicial decisions, which some say that has complicated things to the extent that even though they are reading into the law, they do not provide clear text how it takes place. So they make reference to the J2 matter on prima facie determination. So it has put it in there. It doesn't tell us at what stage should a person be heard. Is it before? Is it when the president receives it immediately? Do we need to have a clear overhaul just to make things more predictable?
So I believe in a living constitution. What it means is that the constitution would undergo reviews, either by legislative measures, by judicial decision, or even by practice.
On 3FM,
you know, these are some of the ways that constitutions grow. The fact that constitution can grow, that the fact that we think we can improve our constitution, doesn't mean that what we have is terrible. You understand? So, for example, if the argument is that the process is not detailed enough, of course, we can make constitutional instruments, or we can make other laws to detail out the process, which is fine. What I do not subscribe to is to say that because of want of that, what has been done is wrong and is unfair. You know, that is where I have a problem, because you can't tell me that, for example, you said the Constitution didn't give the specific number of days that you should return a prima facie decision, or the specific number of days that the committee should conclude its decision, or the details. So because of that, then whatever has been done is unfair. That argument doesn't wash. But if we say that, okay, we have gone through a process, we have identified a few things that we can improve upon, so let's take steps to do it, fine. But that does not invalidate that which has been done under the law as it is.
Let's talk about Oral now, Operation Recover or Loot, a big campaign promise before the government came into office. Almost 9 months down the line, 2 cases, the SkyTrain one, and the other one involving the former National Signals Bureau chief. Would you say Oral is on course?
Oral is very much on course. It's so much on course, and sometimes I look, you know, as I sit here, I look at the Ghana Police Service, I look at Yoko down there, and I see BNI on the other side, and beneath where I sit are hundreds of attorneys, and they're having sleepless nights, you know, investigating. So let me take this opportunity to explain the process of the criminal procedure to the public. I think when I do that, it will at least let the public know what is going on, so that the allegation that, or the complaint, I understand the complaint, okay? Because so much, you know, a lot happened in this country, the citizens became aware of it, and they are eager for justice. And I understand that, and I subscribe to that eagerness. And actually, I get, every morning I get not less than 100 tags on social media. And out of those tags, about 99% of them are asking me what is happening to Oral. And I read them every day. And I thank you for giving me the opportunity to address that. So to take someone to court for a criminal, you know, trial, first of all, there must be a complaint. The Oral Committee, which was set up immediately after election, their main job was to assemble complaints, because that was a time when people did not know exactly where to go to make complaints, or people have even lost confidence in some of the law enforcement institutions. They are not sure that if they go and give a complaint to, let's say, institution A, it will have any effect. So the Oral Committee was to serve as that assembly point for various complaints. After that, so they compiled their complaint. You cannot go and arrest someone and throw the person to jail or take someone to court merely on complaint. There must be investigation. So that's the next stage of the criminal process. So after complaint, you come to investigations. Now, investigation means that all those allegations, our agencies, National Security, NIB, that's National Investigation Intelligence Bureau. I think it's Investigation Bureau. And then Police Service, IOCO, they are all out there, and what they are doing is to find the evidence to support those complaints. Because the persons who bring these complaints are not law enforcement. They may have an idea. Some of them may even have some document that they believe is enough, but it doesn't mean that we can go to court with what they brought. So these institutions are day and night going out there, gathering information. That is why you see sometimes when they arrest some of the people, you see the public, they'll go and gather at Yoko, or they'll go to BNI, or go to police service. And that is all part of it. I can tell you a significant number of people who are going through investigation, no one knows about it. They come quietly, they go through the process, they go, they return, they go, they return. So because I am here, I know what is going on. We can't always come out to be announcing every aspect of these things, because when we do so, chances are that we are also being unfair to the persons who are involved, because investigation may lead to no finding against you. Yet, in society, when you are invited by police and you put it out there that this person has been invited, people conclude. So we can't put everything out there. Now, after you gather the evidence, the next stage is for you to build a docket. The docket is for all the attorneys to come together with the investigators on each case to say, we have enough evidence to go to court with. Then you now begin, so it is when the docket is built and we have charges, that is where you see me running to court to go and charge the persons, like the Edubwahini case and the Sky Train, and then we charge the person and say that you have committed this, then you defend. Then the court trial itself starts. I mentioned earlier that the average number of 2 years. Now, let me give you these 2 cases that you mentioned. We have moved so fast within these cases, okay, to the extent that for Edubwahin, we are about 1/3 through the case, 1/3 of the journey through the case. If not for legal vacation, which stops the courts for 2 months, we probably would have closed our case, and then the defense will be open. But we will come back in October and then continue with where we left from. That is super fast. That is very, very fast if you compare it with all the other criminal trials that we are even doing here. But I understand, I know after this, I'm sure one of the bites you put out there is that Deputy Attorney General says the oral is super fast. So then the public will say, but we don't see anything. But the point I'm trying to make is that the expectation is legitimate because of what we have witnessed. But the work we are going through and we are doing is very thorough and is vibrant. I hardly sleep. But the bigger point here is that the public would have to, as it were, be also made aware of the processes. That we can't just bundle people based on complaints and throw them into jail. So someone says 8 months down the line, nobody's in jail. We have done 8 months. We don't see anybody in jail. The people are still walking about, and some of them are giving interviews. But there's no law which says that if you are being prosecuted.
In fact, they've made reference to the National Service Secretariat one. The lady involved that the Attorney General spoke about her. She participated in a recent GFA event, and we saw, if you go on social media, you see the comments. People are saying, that all what the AG said, how is the matter not in court?
Yeah, why is he still contesting and winning election and we are here? How is Edubahin granting interview and talking about Omani being his good friend and all? We have to, there's nothing really we can do as law enforcement about people's rights to contest, because the position of the law is that you are innocent until you are proven guilty. The person has not been proven guilty. So for the public, let me make this point, that the concerns are legitimate. There's no doubt about that. The concerns are legitimate. But the processes of the courts and the criminal procedure is also, you can't, there's no point in rushing, and at the end of the day, the person will just be discharged, So what I can say to the public is that my good friends out there, they should keep the pressure on us. They should keep the pressure on us. We need the prompting, we need the pressure to be motivated to continue the work. We are motivated, but without their constant reminders, without their constant tags, without their constant, calls on us that we should move fast, chances are that we may feel complacent. So we agree with what they are saying, but we are following the process, and I'm saying that we will deliver the mandate that they have given to the government. President John Mahama's government's promise is that we are going to correct all the injustices that have been done to the public purse. We are going to ensure that people are brought to book and examples are set for people to know that when you abuse public office for private gain, when you take public resources and you pass it off into your pocket as your own property, you will be dealt with. And that agenda is on and will not stop. And the motivation that we get from the public comment is also very much needed.
On the process, the agencies that work with you, or basically under your supervision, Yoko particularly, in the last couple of months, the concern has been the bail bond, the sum that they are fixing. I mean, the argument is that sometimes they fix huge sums in a manner that basically they've granted you bail, but you end up being kept for more than 48 hours. I mean, your ministry is responsible for justice as well. And when you're in private practice, I remember you've raised issues with how bail is handled generally. Do you find this to be consistent with the legal provisions, Article 19, Article 14?
Yeah, so I understand the public concern, but this is what law enforcement and even the courts take into account when they are granting bail.
Sunrise
they look at how much is involved
the best in the
alleged crime. They look at the possibility of the suspect or the accused person running away, that is flight risk. They look at the possibility of the accused person interfering with further investigations or trying to pervert the course of justice if it's granted liberty. Now let's focus on the value involved. I understand why the people are shocked about, or they feel that the bail bond, the amount is huge. That is because the crimes we have investigated are unprecedented. I mean, someone is alleged or has been accused of taking 500 million Ghana cedis, and then the bail is, you want the bail to be 2 million. I will pay the 2 million and go and not come back. Do you get the point? Mm-hmm. So the bail, as the courts themselves have decided, should match with the gravity of the offense. That is what it is. So if a few of those cases have moved from the law enforcement, have gone to court, and even when court granted bail, it was still difficult for the people to satisfy the condition. For example, in SkyTrain, one of the accused persons, after being granted bail, was still in custody. It took the person a very long time to satisfy the condition in terms of the amount. What it means is that the law enforcement agencies and the courts have agreed or are agreed on the gravity of these bail conditions. So, yes, it may be outrageous to you that someone is supposed to pay millions of cedis for bail, but we need to also find out what amount of money the person is accused of stealing or of misappropriating or causing financial loss. And when you look at that, you will see. So, for example, some of the people who have brought the suspect, investigation showed that they have properties that are more than what you think the bail is. Now, if you give a bail condition which is below, and the money they are accused or they are alleged to have stolen is also huge. So you sitting out there, this is huge, 2 million is huge. But the person deep down his own heart knows that, look, if I can look for this money and pay. You know, so I don't think that the courts have been excessively harsh, and the few times that reviews have been sought in respect of those bail conditions that the law enforcement agencies have granted, the courts have marginally remained within the same framework.
Sunrise on 3FM, the best in the morning.
And that was a conversation with the Leonard Deputy Attorney General, Dr. Adam Sremsai, sitting down with my colleague, Joseph Akablay. We'll take a quick break. When we return from this break, there are birthdays here, and then we will kiss the day goodbye to welcome 3 Lounge with AJ Akwakusapon.
Luck is everywhere.